Gentlelady from Texas.
Thank you, Mr. Chairman. I think I just want to kind of distill down what my colleague, Ms. Jayapal, was talking about, and I am definitely going to yield some time to her. I think our concern is that because somebody says something, that doesn't make it evidence. And right now, what we have is people saying, well, we have evidence. As attorneys, we know that that evidence has to be tested in court, and that is what due process really looks like. It's not just saying that somebody is MS-13. It is a matter of a judge determining whether or not that evidence would be admissible and having the ability to look at the credibility of the witness offering that evidence, such as when we're talking about Kilmer. If we look at that, it says, I've got a couple of articles. There's an article that says government's case against Abrego Garcia is based on PG County cop who was on the SA's do not call list because he was not a credible witness. The only person that said that he was MS-13 is a cop that ended up being, I don't think he got fired, but he definitely, never mind. He did get fired. So we're going to say that we're going to base our entire case, so to speak. This is why we have courts. This is why we are talking about due process, because that's what it looks like. It looks like more than somebody, listen, I can't tell you how many lies are made up by MAGA followers about me. I done been all kinds of things, and none of it is true just because they put it out there on social media. That is the problem that we're having right now in this country, is that it seems like nobody cares about the truth anymore. And what we're trying to do is say we have a fact finding, and let me be clear. I am not saying that the criminal justice system or any other justice system has ever always been perfect. I am not trying to say that. But we do have a system, and that system is supposed to be based upon the Constitution. And right now, like literally due process comes from the Constitution. This should be the highest protections that one can have in the land. And right now, it seems like y'all don't care about the Constitution unless it's the Second Amendment, and that's misinterpreted as well, okay? There's other amendments to the Constitution, and we don't get to just change it because our fearless leader says that he doesn't like certain parts of the Constitution. We have a process, again, to get amendments. Right? There are people that don't like the fact that there was an amendment so that women could vote. And guess what? We ended up with something like the SAVE Act because we don't want women to vote. Like, literally, but I'm getting off track, so I'm going to go back because I know that Ms. Jayapal wanted some time. So I will yield my time to the gentlelady from Washington.
Thank you so much, Representative Crockett. Look, I want to go back to the amendment, which says nothing in this bill can be enacted until we follow the courts and return these wrongfully deported people to the United States. And I would thank the sponsor of the bill for at least ensuring that there's a conviction in this bill. A lot of the bills around immigration that have been brought up to the floor of the House do not require a conviction. And so I appreciate that you put a conviction in.
Not too late to co-sponsor.
I believe that that is an important threshold that should be, and I hope that maybe you voted against all those bills. I'm going to go back and check. I don't think so, but maybe you voted against all those bills that didn't have a conviction, because we voted on a lot of them, and they don't have convictions. So I appreciate that you put in a conviction here. Here's the problem. I think you believe in due process. You said you have experience arguing in courts. I assume that you respect court decisions, but I have not heard a single person on your side speak out and say that the administration must return Kilmer Abrego Garcia to this country when the President of the United States said he had the power to do that. And when you say to me, oh, there's all this information on Mr. Abrego Garcia, and he's this and he's that, I guess I'm surprised at that, because if you really believe in due process in the court system, and I believe you do, I'm going to give you that benefit of the doubt, then why not present that information in court? The Trump administration has refused to present information in court. They have, and the judges, when they've looked at the things that are there, they're saying, nope, not good enough, doesn't meet the standard. So why don't you all issue a statement from the Judiciary Committee Republicans, happy to co-sponsor it with you if you'd like, that says that you believe that the Trump administration should follow the ruling of the Supreme Court of the United States and any judge that rules, including those judges who were appointed by Donald Trump, to return these wrongfully deported individuals to the United States, because it is undermining everything that you've done in your career, everything that we stand for on this committee, to not speak out about it and to act like somehow this is okay. I think whatever you believe about Mr. Abrego Garcia, you should be able to say that he should have due process and that the Trump administration should follow the Supreme Court. So if you, and I think that this is relevant to this bill, and so I hope that we can do that together. I doubt it, but I hope we can do it together.
And Mr. Chairman, I have 2 UCs. The first one is this article that says governments, what I said before, but more specifically, Mr. Menendez filled out the gang-filled interview sheet that deemed Abrego Garcia a member of MS-13 based on the fact that he was wearing a Chicago Bulls hat and hoodie.
Objection.
And the other one is, it says Trump's case against man deported in error just took another big hit. Trump world claims Kilmer Abrego Garcia was in MS-13, but new information concerning the local cop who attested to that charge at the time raises fresh questions about it.
Without objection.
Thank you.
Gentleman from California is recognized.
Thank you, Mr. Chair. I just wanted to briefly address a point brought up by the representative from Texas, Ms. Crockett, who accused me and my colleagues over here of ignoring the Constitution. And if that were true, that'd be a very serious matter. So I did want to just inquire as to what exactly the accusation is. So I'll happily yield to the gentlewoman from Texas if she'd like to respond. Do you believe that someone who has snuck into our country, entered the United States illegally, that the due process requirements for that individual are the same as they are for a U.S. citizen?
I thought the question was for me, but it seems like the lawyers on this side or just my entire team knows the answer.
Mr. Chairman?
Per the Constitution, yes, if you are on our soil, you are guaranteed due process. And the fact that there's even a question is why we are struggling right now. In addition to, an additional issue that I have is the executive order that was signed by the president that seemed to get rid of birthright citizenship, which also is laid out in the Constitution, which is why even the most conservative judges have ruled against, there is no one that has ruled that that was okay.
Okay, thank you.
You're welcome.
So
Thank you.
that's simply untrue. The Supreme Court has made it very clear that due process is a context-dependent inquiry. And someone who is here illegally in this country facing deportation, the requirements of due process are specific to that context. And the problem is that during the last administration, we had 10 million people who came into this country without the least amount of vetting. And it's created an enormous backlog in our immigration courts. Now, what we actually did in a measure that we passed in this committee a couple weeks ago, which I believe every member of the Democrat minority opposed, is we sought to provide the resources for our immigration courts to operate in a fair and efficacious manner by increasing the number of immigration judges, of lawyers, of courtrooms, in order to remove this backlog of millions of cases that now exist. So I think it's highly problematic to hear arguments about due process from the side that is actually voting against providing the resources that are needed for due process. But I think it's even more problematic to make the argument that an illegal immigrant, perhaps with a criminal record facing deportation, should receive the full measure of due process that an American citizen does. That simply is not what the Constitution requires. I yield back.
Mr. Chairman?
Can I answer, since you still have time?
Yeah, I'd be happy to yield for a response.
Okay, thank you so much. So I just want to clarify, and I know that there's lawyers on that side. It's just like we have different standards in general. Like, you have a higher standard when it comes to a criminal case versus a civil case, right? So it's preponderance is going to be the burden on a civil case, and then it's going to be higher as it relates to a criminal case, right? It's beyond a reasonable doubt. That is going to be the burden of proof. When the Supreme Court was making distinctions, the distinctions weren't necessarily between, is this person a citizen or is this person not? It wasn't a matter of certain people are not allowed to have due process, but it's kind of like there's different ways to evaluate things. The amount of protections that you are going to have in any criminal case. If you think about those that are charged with murder, whether they are a citizen or not, guess what? The burden of proof is still going to be the same. The burden of proof is still going to be beyond a reasonable doubt. There was never a distinction that said somehow, dependent upon your status, you somehow lose your access to due process. And frankly, that is honestly the only thing that the Supreme Court has been consistent on, is that there are due process rights that are going to be afforded to everyone that is found within our jurisdiction in the United States. I have not seen a case where they have said, no, it's okay for someone not to have due process. That is why the plane that was about to leave Texas, they said stop the plane literally at 1 a.m, because there had not been due process for those that were currently being held in the administration's custody. And thank you so much.
Thank you. I think I understand your position a little better now. I can't say I agree with everything you said, but I would just say perhaps be careful with throwing out accusations or ignoring the Constitution, without carefully considering those statements, because the demands of due process is not just something that is the same in every context. It's
Mr.
very
Chairman,
much
I have a
context.
unanimous,
So I yield
have
back.
a unanimous consent request.
Gentlelady is recognized for unanimous consent.
I'd like to submit for the record the Constitution of the United States Fifth Amendment explained, so that the gentleman can see exactly what is in the Constitution, where it says no person shall be deprived of due process.
I would just point out the Supreme Court, as the gentleman from California has said, has firmly, I'm quoting the Rehnquist from Justice Rehnquist, has firmly and repeatedly endorsed the proposition that Congress may make rules as to aliens that would be unacceptable if applied to citizens.
But
There
currently
is
the
process
Constitution
due, but
says-
it's not the same process due American citizens.
Mr.
Without
Chairman, it
objection-
just says no
without objection,
person,
the
and
Fifth
so-
Amendment will be entered in front of the Judiciary
Thank you
Committee's
so
record.
much. I just
even
wanted to
though-
make sure everybody knows what the
even
Fifth
though
Amendment says.
we will take
Maybe
it.
we could introduce the 14th Amendment too, Mr. Chairman.
Okay, that's fine too. Well, you can introduce the whole Constitution. God bless you. Now I got 3 of you who are in line, and I'll defer to the ranking member because he's one of the 3 in line. But you can decide. You
Cool,
can
but,
pick.
but let me go first. It should be quickly, guys.
Okay.
A few questions for Mr. Knott. I do want to reemphasize what the gentlelady from Texas said, which is, of course, the civil standard of proof is different from the criminal standard of proof. The criminal standard of proof that governs is beyond a reasonable doubt for both citizens and non-citizens before someone's criminally convicted. In the civil context, depending on specifically which one, it could be by preponderance of the evidence, it could be clear and convincing evidence. There are different ways of formulating it, but the critical point for everybody to understand is that the Supreme Court has said on a 9-0 basis that there must be due process before people are removed from the country. Okay, I want to get back to Mr. Knott because the distinguished chairman of our committee advanced some questions, and of course it's always dangerous to base your image of what legislation does based on one hypothetical. So he offered a hypothetical relating to opioids and cartels. There's nothing in the language of your bill that requires proof of somebody being involved in a cartel or dealing opioids, right?
Oh, no, absolutely not.
That's not an element. Okay. No. And then our distinguished colleague from California, Mr. Correa, he offered a kind of different hypothetical.
Yes.
And of course, the chairman's is perfectly plausible, but his is perfectly plausible too. He says, you've got people, there are tens of millions of them, who are coming to America drawn by employers who are willing to pay them. And there are tens of millions of them working in the fields, working in retail, working in construction, doing landscaping, and so on. A person, now, and here's where I want you to just help us tease out the meaning of your legislation, okay? The person I'm hypothesizing here is not an opioid dealer or a cartel member. This person has come over in the spirit of the people that our colleague from California is talking about. So comes to take a job on the farms, but he's there illegally. Now gets deported, so that's strike number 1. he could be held for 6 months under current law.
Existing law.
Existing law.
Yep.
If he does it again, it's 2 years, but you want to change that to 5 years.
No.
No?
To you yield?
Please.
So the qualification for a 5-year minimum is conviction of a felony here in the United States, while here illegally. That's number one. If in your hypothesis, Mr. Raskin, when that individual is deported and returns with no conviction, instead of 0 to 2 years, he would be subjected to a penalty of 0 to 10 years.
Wait, I say that again for the second time?
Yes, for illegal reentry, the penalty is amended from the existing law right now. Illegal reentry is capped for most cases at 24 months. That would be changed to 120 months, from 0 to 120 months. So there's
For the first or the second?
illegal reentry.
Okay.
You're talking about 1325.
Okay, you're referring to 1326 now?
Correct.
Right, okay. All right. I guess, so here's what I want to get at in the limited time I've got. On the second round, they could be held up to 10 years under 1326.
Illegal reentry.
Okay,
Yes.
would you go to page 5, if you would, on the amendment in the nature of a substitute? If you go to the bottom of the page, okay, and then this is where maybe I'm getting confused. Mandatory minimum criminal penalty for reentry of certain removed aliens, right? So if you were convicted of being removed 2 times, if you're the person who's been drawn by the magnet of a salary, an income for your family, like the one Mr. Correa was hypothesizing, right? And you've done it twice, that person may be fined under 18 U.S. Code and shall be imprisoned not less than 10 years. And then the other part I don't understand, if you would clarify this, and may be imprisoned for any term of years or for life. So I don't know what that means. Is that a drafting error? Or?
Again, the crux of this issue with the enhanced penalties requires a conviction before the enhancements are applied. So if someone is convicted of a felony, deported, and then illegally re-enters, or if there's enhancements that are spelled out on page 5, that's when the enhanced penalties are triggered.
But can you just explain, what does it mean to say, shall be in prison not less than 10 years? That does sound like a mandatory minimum, which I thought you were disclaiming before.
No,
but
no.
then, and may be in prison for any term of years or for life. Then suddenly it can become a life imprisonment. Is that right?
There's the way it's written, there's flexibility there, up to life. That's the intent of the bill.
The time of the gentleman has.
But may I respond briefly? In regards to these charges, there's always an element of prosecutorial discretion. A great example in today's world is marijuana is still illegal federally. It's everywhere. Prosecutors are choosing not to charge that. This bill gives the tools to law enforcement to go after, in an efficient way, the committed criminals doing harm in the United States. That's the target. And they're again, illegal reentry or a conviction is what triggers the penalties of this bill.
Time of the gentleman has expired. The gentleman from Kentucky is recognized.
Thank the chairman. I want to speak to the bill generally. I think it addresses an important problem. I think it's a serious bill, and I think something needs to be done. But I cannot support the bill with mandatory minimums. I've been here a dozen years and haven't voted for a mandatory minimum. I think mandatory minimums run afoul of the intent of the structure of this government, which is to allow the judges and the juries to have discretion, because we cannot foresee here in this committee room every circumstance that might arise in the prosecution of these cases. And although I think it's otherwise a great bill, I will not be supporting it because it has mandatory minimums. Thank you, and I yield back.
Gentleman yields back. The gentleman from New York, and then the gentleman.
Chairman, I want to pick up where the ranking member left off. Whatever the intent of the sponsor may be, the bill clearly says that someone who enters the country illegally twice shall be imprisoned not less than 10 years and may be imprisoned for any term of years or for life. In other words, if you come across the border twice, you can get life imprisonment without committing any crime other than illegal entry. It seems a little draconian and to have the possibility of a life sentence. In addition to which, you can be imprisoned for 10 years or up to life, and there's no standard for when it should be 10 years and when it should be life or 20 years or anything in between. There's no guidance for the judge. And unlike what I think the sponsor said, there is no requirement for a felony as a precondition to a life sentence. All that is required is 2 illegal entries.
Will the gentleman yield?
I will.
Line 9, it says, who was convicted under this section at least 2 times.
Yes.
Convicted.
Convicted of
convictions.
2 illegal entries. Yes, no, I'm not quarreling with that. So in other words, if you illegally cross the border twice, you shall be sentenced to at least 10 years and up to life for no crime other than illegally crossing the border twice. And there is no guidance for the judge as to whether it should be 10 years or 20 years or 30 years or life. Most statutes, in fact, all statutes, give some guidance for the length of prison. This doesn't give any guidance for the length of prison. It simply says if you've entered the country twice, you can be sentenced to at least 10 years. All right, can't be sentenced to 5, at least 10 years, but up to life, and no guidance within that.
Gentleman yield?
I will.
Well, again, part of this goal's aim is to deter.
What?
It is to deter. It is to deter illegal reentry.
Reclaiming my time.
Yes.
I don't doubt it's to deter illegal entry, and it certainly does that. But it still gives no guidance to the judge as to whether to sentence someone to 10 years or 11 years or 12 years or life imprisonment. And that doesn't make any sense. If you wanted to say, if you wanted to say that the first illegal entry shall be sentenced to 5 years and the second to 10, or the first to 10 and the second to 20, it'd be a little harsh, I think, but it would make sense. But to say 10 to life with no guidance to the judge, with no standards, that makes no sense.
Gentleman yield?
I'll yield to Ms. Ross.
Thank you, and I'm going to want some of my own time after you do that. I wanted to make the point, and we've talked about this. You and I both represent North Carolina. We've talked about what you want to do, your main reason for even being here. This bill is everything to you. So I would hope you would want it drafted well. And I think the point that's being made here is, in addition to the mandatory minimum that Mr. Massey has raised, there isn't a disjunction between anything that's even longer than that. It actually says the mandatory minimum of 10 years and a prison sentence for any amount of time or life. And so it's not giving the judge the option of choosing between them. The judge has to do both. And so I just would ask the gentleman to consider that that might be a drafting error and not his intent. And, you know, it's going to take a long time for this bill to go everywhere. You know, the Rules Committee may never stop, and you may never get to rules. So let's take a little time. And if that is true, if it's truly your intent to give some judicial discretion to make sure that this bill doesn't mandate that judges do that.
Reclaiming my time, this bill says not less than 10 years and may be in prison for any years to life. It gives no discretion, it gives total discretion to the judge, no guidance, and that's the problem with the bill, in addition to its harshness. I'll yield.
Well, just briefly, again, a goal is deterrence, number one. Number two, mandatory minimums can be penetrated upon motion of the government. That's a well-established fact for substantial cooperation, 18 U.S.C., I think it's 3553E. Thirdly, mandatory minimums, whether it's drugs, continuing criminal enterprise, firearm statutes, et cetera, there's no discretion for the judge. That's what the attorneys...
Reclaiming my time,
that's what the attorneys...
It is a mandatory minimum in the bill.
Gentleman doesn't have time to reclaim.
And it is a mandatory minimum in the bill, and the maximum is life, and I would simply suggest that in looking at this bill, you give some standard to the judge for what to do. I yield back.
Gentleman yields back. I've kept Mr. Goldman waiting for 4 people, so I'm going there next, and then I'll come back to the gentlelady from North Carolina. If we don't, well, I'll go first, Mr.
Thank you very much, Mr. Chairman. My colleague on the other side of the aisle who shares a glorious past as a federal prosecutor in the DOJ with me says that the goal is deterrence of this bill, that deportation alone is no deterrent to returning here. I think the chairman said the goal of this is to prevent members of the cartel or parts of terrorist organizations from coming back to this country. And it almost feels like we are living in completely disjointed universes from what is happening down the street, where the president and his administration is desperately trying to deport people before their criminal case is completed. And in fact, my colleagues on the other side of the aisle passed a law that allowed for removal based on an arrest, based on allegations. So when my colleague from North Carolina and Mr. Issa from California talk about how this bill only applies to people who have due process, how can you square that with the fact that you supported the Lake and Riley Act, which does not include due process? And how can you square that with the fact that you haven't said anything in opposition to this administration's deportation of people without due process who have not had their day in court and have not gotten what you believe to be the benefit of deterrence from a criminal prosecution and a sentence? So you have a bill here that is ostensibly designed to increase the penalties against those people who illegally re-enter to deter them from doing that. And yet, you're also passing bills and supporting an administration that does the exact opposite. It's almost as if we're living in completely different universes. And in fact, the universe is so different that I want to flag a particular case for my colleagues on the other side of the aisle. Not too long ago, this Department of Justice dismissed a case against an alleged top leader of the MS-13 gang, who U.S. investigators believe has information that could implicate top Salvadoran government officials in possibly corrupt deals with the violent gang. And he was removed on one of the controversial flights that is the subject of litigation. So the United States Department of Justice worked hard as part of the task force Vulcan to extradite this individual to face charges in this country. Charges, very serious charges related to terrorism, racketeering, murder. And this was a top person in MS-13 who either would have served a long period in jail or perhaps would have cooperated and provided the United States government with very relevant and important details about MS-13, one of those cartels, one of those terrorist organizations that the chairman talks about. But rather than allow the deterrence to play out and the person to go to trial, this MS-13 terrorist to go to trial, be convicted, and serve a lengthy sentence, which is the whole thrust of this bill, this administration decided, no, we're just going to let him go back to El Salvador. And so that is the exact opposite. That's what you're worried about. That's what you're worried about. If we just deport people, they'll come back. And yet that's exactly what this administration is doing with top cartel officials and terrorists. Now, I have no idea whether this was a side deal between President Trump and President Bukele that is related to the payments that President Trump is making to President Bukele in order to imprison prisoners. There's no question, there's on the record reporting that President Bukele is in opposition to extraditing members of MS-13 because they may have information about him. So I don't know what the derivation of this was and why it happened, but what I do know is that this is a cartel member who was extradited, charged, would have gone to jail for a long time, and was dismissed by this Department of Justice just so they could deport him. So why don't you speak out against that rather than trying to elevate these illegal reentry prisons?
Gentleman's time has expired. The gentleman from California is recognized.
Thank you, Mr. Chairman. For 4 years, the Democrats deliberately flooded our country with more than 8 million foreign nationals who violated our immigration laws, illegally crossed the border, and the Democrats then trafficked them across the country, including the most violent criminals and criminal gangs and cartels on this planet. This administration was specifically elected by the American people to protect our citizens, secure the integrity of our borders, and restore the rule of law. Now, regarding the Democrats' obsession with returning Abrego Garcia to our country, the record's very clear, and I'll state it again. He was determined by 2 immigration judges to be affiliated with MS-13 after being arrested in the presence of known MS-13 members, wearing gang insignia and a gang tattoo, and in possession of $1,200 in cash and drugs. A confidential informant confirmed he was a mid-ranking member of MS-13. He was denied release on bond because while his immigration case was pending, because of the potential danger that he posed to the community. This is precisely the type of individual the Democrats want returned into our neighborhoods. This is exactly the kind of individual that this bill attempts to protect us from. The Democrats have made it clear, time and again, that if they're ever returned to power, this nightmare will resume and Americans will be held hostage to the most violent criminals in the world, protected by Democratic sanctuary laws and shielded by woke Democratic district attorneys. That is the choice that faces the American people. This administration was elected to protect us from this deliberate subversion of our laws, and it's doing everything that it can despite the opposition from the Democrats. The Democrats argue that even though he was ordered deported, he was ordered not to be deported to El Salvador, even though he's a citizen of El Salvador. Now, that order was not known to ICE when he was deported. It should have been, but it wasn't. Bureaucracies make mistakes. They shouldn't, but they do. Point taken. But now, what's the status of this case? Abrego Garcia is a citizen of El Salvador, in the custody of the government of El Salvador. The United States has no jurisdiction over him whatsoever. Now, the courts ordered the president to, quote, facilitate the return of Abrego Garcia, but it's conveniently failed to define exactly what that means. I think the reason for that is because they can't think of any act the president could take that a court can compel. If they could think of one, I think they would have specified it. So they leave an entirely ambiguous word because they can't define specifically what they mean. It's very clear that the court cannot compel the president to facilitate or conduct foreign policy, and yet that's the only order they could issue to facilitate Abrego's return. So I think the Democrats need to exercise a little self-reflection here and consider the position that they've taken and the danger that it poses to the American people.
Mr. Chairman?
I yield back. Yes, I'll yield to the...
No, I'm not asking for you. I'm asking for my own time. Oh.
Yielding, and I appreciate the context and clarification that he gave to the Abrego Garcia situation and to this bill. I just want to make sure that the committee understands what Mr. Knott is doing here. My understanding is the first time someone comes in the country illegally, that's a misdemeanor. They come a second time, it's a felony, and currently they could get 2 years. What this bill is going to say is, oh no, if they come in the second time, they could get up to 5 years with the judge. And then if they're kicked out again and they come back a third time, then it could go to 10 years or greater, again, up to the judge. And it's designed to make sure the Abrego Garcia guy doesn't keep coming back and doing bad things. Is that clear? And that's the experience of the gentleman who worked as assistant U.S. attorney. Is that And I'll yield to the gentleman for response.
Well, essentially, that's correct, Mr. Chairman. The provision of the bill says if you're here illegally and you receive a felony conviction, state or federal, you qualify for a new charge, 5 to life. If you're deported and come back, regardless of criminal history, 0 to 10. If you come back illegally for a second time with a felony conviction, that's what qualifies you 10 to life.
Mr. Chairman,
It's very straightforward. If you are, again, I will state this again, if you are here illegally and you do not commit a felony, this law does not apply. This is for the hardened criminal that is inflicting harm on this country, period.
Gentleman
Time
yield.
has expired.
Would the gentleman yield?
I will recognize you for, I think you're up next.
Okay. Let me,
I've got 2 UCs, Mr. Chair.
Hang on one second. We'll take the UC, then I think someone had to yield this.
Okay, so the first UC is Mexican security chief confirms cartel family members enter U.S. in deal with Trump administration. That's from the
Objection.
Associated Press. And then there is another article. Is that admitted? Unanimous consent? Okay.
Yep.
The other one is what we know about Trump admin's reported deal allowing Mexican cartel family members to enter U.S.
Without objection.
Thank you.
The gentle,
They letting the cartel.
If we can get off the amendment, they all have time on the other ones.
okay, but I think we got to get someone,
If we can get off the amendment, then everyone.
then you can claim time on the bill.
You'd be recognized first on the next one. Is that all right? Because they want to call the vote.
Question, I got it. The question occurs on the adoption of the amendment.
The amendment from the gentlelady.
Oh, that's right, the gentlelady from Washington. Question occurs on the amendment offered by the gentlelady from Washington. All those in favor say aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it, and the amendment is not adopted. Roll call, then we'll come to Mr. Nadler. Clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa?